Hey, this is Larry Goins. How's it going? Today I'm going to go over some training with you on the SAFE Act. Now, some of you may or may not be familiar with the SAFE Act. Actually, the SAFE Act is a federal law that was put into place to regulate mortgage lenders and brokers. However, the way it affects investors, there's one paragraph in the general statute that addresses seller financing. Now, in that general statute, in the paragraph, it says if an individual is selling their house and it is not their primary residence, then they must be a licensed mortgage loan broker to be able to sell that property with seller financing. I mean, what is that about? We can't even sell our own house, whether we live in it or not. Now, if you live in it, you're exempt, okay? But if it's a rental property or property you've had for a long time, or you're buying to sell it with seller financing, you got to be licensed. Why is that? Now, Congress did not really mean for this to limit investors. Okay, so HUD is going through, as of this date right now, HUD is going through, and they've made a statement about it, but HUD is going through, and they're getting all states to come up with their own rules and regulation for the SAFE Act. Okay, now remember, majority of the SAFE Act is to protect consumers from unscrupulous lenders, okay? But because of the whole process of HUD waiting on all the states to come up with their own compliance, their own rules and regulations as it relates to the SAFE Act, then this is a part of it as well. And I've actually been on the phone a couple of times with a gentleman up at HUD in Washington, D.C. about this. And he said what they're doing is during this time frame right now, they are working with the states to come up with their own state compliance rules and regulations. Some states have already adopted the federal SAFE Act as their own, and some have not done anything, and some have adopted their own that's similar to the SAFE Act but has other rules and regulations as well. In fact, like Texas has adopted what they call the T-SAFE Act. Texas SAFE Act, and it's even a little more stringent than the federal SAFE Act. So anyway, if you were selling a property very similar to what we do with Filthy Riches, okay, where we're buying a house at $5,000, we're selling it with seller financing for $30,000 with a low down payment, and we get payments more than you could get if you were renting it out or anything like that, because we haven't even done the work to it yet, okay? So if you're selling a property with seller financing, the guy at HUD told me, first of all, you have to look for your own local state's rules and regulations. And what you'll do is you'll contact your state's banking commission. In fact, if you will Google the word, say you're in Arizona, you Google Arizona Banking Commission, okay? And you will find their website, and then you start searching about the SAFE Act or seller financing. You will even get a phone number. They typically have counsel on staff, and you could call them and ask them, say, I own a house, or I'm getting ready to buy a house, and I'm going to sell it with seller financing. So what do I need to do to stay in compliance with the SAFE Act, or is there anything I do need to do? So you can do that, and I would suggest you record the phone call, or you ask them to email that to you and let you know, or email you the paragraph or the general statute or whatever it is for that state that lets you know that you can do this, okay? It's been my experience that I have found that in doing this in multiple different states, we always do this, we always follow through, but I gotta tell you, most of the states, most of the realtors, most of the attorneys, most of the title companies, they don't even know anything about this. They are closing deals every day, and they have no idea about anything regarding the SAFE Act and seller financing. So I just want you to be aware, okay, because this is something new, nobody's enforcing, nobody's doing anything about it, but I don't want you to make any mistakes, because I'm doing it, and I'm doing it right, and I'm following through, and you can too. So first thing you have to do is contact your own state's banking commission and see what kind of rules and regulations they have, all right? Now, if they don't have any, then I would suggest you follow the federal SAFE Act. And here's the deal, okay? When I spoke with the gentleman up at HUD in Washington, he said there's basically a few ways you can get around, not get around in a bad way, but comply, I guess is the best way to put it, with the SAFE Act. So number one, the first thing you could do if you're going to sell a property with seller financing and you are not going to, and you don't live in it, say it's a rental property or property you just bought, well, the first thing you have to do is get licensed. Get licensed as a mortgage loan broker or mortgage lender. Now, we all know that's not realistic unless you are already in the mortgage business, okay? So that's the first thing you can do, which I would, quite frankly, I would forget about this unless you're already licensed as a mortgage loan broker in your particular state or where the property is, okay? The second thing you can do, okay, is sell the property to a corporation or LLC or any other type of entity. The SAFE Act is to protect consumers. A corporation and an LLC is not a consumer, okay? So you can sell the property if you're selling it to an investor, deed it to their corporation, but get them to sign personally and give you a personal guarantee on the note and mortgage or deed of trust, okay? So deed it to their corporation or LLC. You know, it might be ABC Investments. Now, you can't do this if you're selling it to somebody that's going to live in it, okay? Because the law is to protect consumers, and consumers have rights. So don't do this if you're going to sell it to somebody that's going to live in it. Only do this when you're selling to investors. And I got to tell you, with our Filthy Riches concept, which you can find more about that at filthyriches.com, but on our Filthy Riches concept, we're actually selling most of our properties to other investors because the payments on these properties, we can buy it for $5,000, sell it for $30,000, and their payments are actually less than rent, and then the buyer fixes it up, and then they rent it out and get a cash flow on the property. Okay, so that's the second way, which is a good way to do it. Now, the third way is also a great thing you could do. You can pay a mortgage loan broker. They call it an MLB in the business, okay? A mortgage loan broker. And you may pay them anywhere from $1.99 to $2.99 to process your paperwork. Now imagine this. You were selling a house for $30,000 with maybe, I don't know, $1,000 or $2,000 down. And you're financing, say $2,000 down, you're financing 28 grand. You can't even take your own application. You can't process the paperwork, which, by the way, what you do is you go to docmagic.com to get the paperwork done. And they're guaranteed to be state compliant in all 50 states. That's where we get our docs. That's where most mortgage lenders and mortgage brokers get their docs too. So, but you can pay a licensed mortgage loan broker $199 to $299 to simply take the 1003 credit application and to process the paperwork. There's not even any paperwork to process. DocMagic has all the paperwork. And all you do is send the terms over to DocMagic, you send them to the mortgage lender, and then they send them over to the attorney or title company. Okay? But if you want the mortgage loan broker, they can order your VOEs, your verification of employment, your verification of rent if you want to. They can run the debt ratio, they can pull the credit, they can do all that stuff for you. And here's the best part. This $199 to $299, you don't even have to pay it. Your buyer can pay that. In fact, when we sell a house like this on eBay, we put it in our listing terms that the buyer pays all the closing costs, which usually runs around $750. So we have it that our buyer pays that, okay? And the fourth way that you can sell this property and still be in compliance is sell it either on a lease option, okay, or sell it on a land contract. All right? In a lease option, you have a lease and you have an option agreement. An option gives you the right but not the obligation to purchase the property, okay? And so there's no transfer of ownership here, so the SAFE Act doesn't even apply. On a land contract is simply a document, it's a contract that says you will pay me X number of dollars for X number of years, and after it's paid in full, then I will deed the property over to you. There's no transfer of ownership with a land contract, so it doesn't apply to the SAFE Act as well. So I hope this really helped you to get more information and understand more about the SAFE Act. And remember, no matter what state you live in, no matter where you're doing business, no matter where the property is in, always contact a local attorney in that state and ask them what you need to do to stay in compliance with the SAFE Act and any other rules and regulations you need to be aware of, whether you're doing seller financing or anything else. And that's very, very important, okay? And also, as I mentioned, contact that state's banking commission to find out if they have their own SAFE Act, or they have adopted the federal SAFE Act, or they've done nothing at all. Because as of right now, all you have to do is comply with the state rules and regulations. So I hope this really helped. Thanks a lot. Remember, there's plenty more of these videos like this, training videos on all different topics, as well as articles and special reports, and we're always doing webinars and training teleconferences over at LarryGoins.com. Thanks a lot and have a great day.